Well, good afternoon, everyone, and welcome to today's installment of our ongoing series exploring the amendments to the United States Constitution. My name is Samuel Holliday, and I have the tremendous privilege of serving as Director of Operations and Scholarship for the United States Capitol Historical Society. And we're grateful that so many of you have taken time out of your busy day to join us for this important discussion. Before we get into our fantastic presentation from a renowned scholar and leader in the legal field, I'd like to just do a little bit of technical housekeeping, how we like to use this Zoom webinar platform to engage with you nationwide and in some cases worldwide as we explore public history. If you have any questions for Professor McConnell during the course of today's program, you can put those questions into the Q&A section of the webinar. That looks like two speech bubbles, either at the top or bottom of your screen, depending on what kind of device you're using to join us today. If you have any technical troubleshooting matters, if you think you're having trouble seeing us or hearing us during the course of today's program, you can send those messages in the chat. I will be answering those in real time. But again, any content questions for Professor McConnell should go into the Q&A so Jane can see them and proceed through at the end of today's program. It's now also my great pleasure to introduce the President and CEO of the U.S. Capitol Historical Society, Jane Campbell, who will start today's program. Jane?
Thank you very much, Sam. And thank you to both you and Yanni for all the work that you do behind the scenes to bring these programs to light. We are in the middle of our series about understanding the Constitution by looking at the amendments. And today we're going to be talking about states' rights, federal power, and America's most enduring debate. If you think back, James Madison wrote in the Federalist Papers that the powers granted by the Constitution to the federal government are few and defined, while those granted to the state governments are numerous and indefinite. Yet, Article 6 of the Constitution also establishes the supremacy of U.S. laws versus those of the states. To discuss the still yet contested issue of states' rights versus federal power, the Capitol Historical Society is proud to continue this series on the Constitution, today with a history of our 9th, 10th, and 11th Amendments. Not only do they continue to impact the rights of our citizens and the states in 2022, they are at the heart of the United States' enduring debate over sovereignty. We are honored to have as our featured speaker for this necessary and timely conversation, Michael W. McConnell, JD, the director of the Constitutional Law Center at Stanford Law School. Professor McConnell is a senior fellow at the Hoover Institution. From 2002 to 2009, he served as a circuit judge on the United States Court of Appeals for the 10th Circuit, nominated by President George W. Bush, a Republican, confirmed by a Democratic Senate with unanimous consent. Perhaps you could give some instructions on how to deal with confirmation hearings. Professor McConnell argued 16 cases before the United States Supreme Court, served as a law clerk to Supreme Court Justice William Brennan Jr., and his most recent book is called The President Who Would Not Be King: Executive Power Under the Constitution. Professor McConnell, thank you so much for joining us. Tell us about the 9th, 10th, and 11th Amendments. What do they mean? What did they mean when they were drafted? And what does it mean for today?
Well, thank you. And thank you for inviting me here today. This is a very impressive program you've been putting on. Then I'm going to begin by talking about the 9th and 10th and then get to the 11th maybe at the end. The 9th and 10th were part of the original 10 amendments. There were actually 12 amendments proposed to the states, 10 of which were ratified and which we know as the Bill of Rights. The 9th and 10th Amendments, I think, are the most revealing amendments for the structure of governmental powers and individual liberties under the Constitution. Interestingly, they have not often been litigated in the Supreme Court. There are some 10th Amendment cases. There are even fewer 9th Amendment cases. Their importance lies not so much in doctrine in the Supreme Court that is controlling particular cases, as in helping us to understand the way in which the government is structured and the relationship between rights and powers. To talk about the 9th and 10th Amendments, though, we have to begin with the Constitution itself and what they're designed to accomplish. In a way, although the 9th and 10th Amendments are addressing different issues, rights versus powers, they are both dealing with the same conceptual problem about how to draft a constitution, which is what do you do with a list? When you have a list of things, almost inevitably you're going to leave some things out. It's very hard, no matter what kind of list you're making up, it's very hard to include everything. And how do we read these lists? And the Constitution contains, mostly in Article 1, Section 8, although there are a few others, a list of powers that the United States government has, Congress has. And the theory here is that out of the states precede the United States, and that the people of the United States allocated to the new national government certain powers. Now, within the scope of those powers, the national government is supreme, hence the supremacy clause. The national government is supreme within those powers, but they are specifically defined. Congress only has those powers. All the other governmental powers, and our framers thought these would be more numerous, all the other governmental powers were left to the states. But they did not enumerate the powers left to the states. The states just have everything that's left over. Now, a lot of modern constitutions of other federal systems around the world have done this differently. Canada and Germany, for example, specify particular powers that are left to the provinces or to the lander, but that isn't the way our framers went about it. And we know this even before we get to the 9th through the 10th Amendments from the language of Article 1, Section 8, which says that Congress has the power to, let me read you the exact language from Article 1. All legislative powers herein granted shall be vested in a Congress of the United States. Note those words, herein granted. So it doesn't say all legislative powers are vested in the Congress, but only those that are herein granted. And then the Constitution goes on, especially in Article 1, Section 8, to list a fairly compendious list of powers, which includes, the focus of this is on the national economy, not the state, not local economies, but the national commercial life of the nation, foreign affairs, war. These are the principal areas that the framers allocated to the United States government. They left the kind of fundamental aspects of government that we experience as citizens, mostly to the state. So laws about almost all criminal laws are at the state level, and that was even more so back then. Laws having to do with property rights and contracts and family law, basically the way in which our rights and responsibilities vis-a-vis each other, which are reflected in tort law, all of this was left to state law. The national government was going to focus on external affairs, plus things that affected the nation as a whole. There was no attempt to have a comprehensive national government that could pass laws and regulate people's individual lives and in the states. Now, the main thing that has changed since then is that what had been kind of a collection of local economies has become a real national economy. And so without the constitutional standard necessarily having been changed, the application of that standard is very different in a world in which the entire United States is united as a single economy versus a time in which you could operate, say, a business in North Carolina and never have any particular association or connection with any other state of the Union. So the powers that herein granted, the powers are listed. But then that raises the question, what about the fact that the list is necessarily going to leave some things out? And that's what the 10th Amendment addresses. Now, in the first Congress, the first Congress is almost a second constitutional convention in the sense that the first Congress drafted the Bill of Rights, which is such an important part of our Constitution. And the Bill of Rights is a list of freedoms that we have. Protected freedoms. They didn't see themselves as creating these. These weren't new things. These are mostly freedoms that we have either by virtue of our humanity, the natural rights stemming from the state of nature, or very deep-seated rights in the common law Anglo-American tradition. That's especially rights having to do with criminal procedure. And so these are very familiar to us, and the Capital Historical Society has been doing a series of webinars on these. But these include, the freedoms of religion, speech, press, petition, assembly. That's the First Amendment. The right to keep and bear arms in the second. A privilege against having soldiers quartered in our homes in the third, and so forth. So there's a list. Well, the same conceptual problem arises for a list of rights that arose from a list of powers. What happens if you leave things out, as you necessarily will? And this was indeed one of the leading arguments against even having a Bill of Rights. Some very important, prominent patriotic statesmen like Alexander Hamilton, for example, argued that it was a mistake to add a Bill of Rights. And he made 2 points. One is that the danger is if you make a list, it's going to be incomplete. You're going to leave some things out. And what does that mean? Does it mean we give them up? Does that mean they're not rights? Once you make a list, there's a principle in legal interpretation called expressio unius. Actually, the full thing is expressio unius est exclusio alterius. We lawyers like to throw in a little Latin every so often just to make ourselves sound learned. The idea of this is that if you have a list that includes some things, that it actually has a negative implication, it excludes others. So, I mean, this is common. This is just a common feature of language. So if, for example, the dean of the law school said that second and third year students can take a particular course, you'd know that first year students can't, right? You don't have to say first year students can't. When you specify second and third year students may, that means that the others may not. That's the principle of inclusio unius. Well, so one problem is that when you list rights, you're going to leave some things out. It's actually, it's just impossible to list all the rights we have. And in the first Congress, somebody pointed out that if we were going to try to list all of our natural rights, we'd have to mention the right to wear a hat, or to or what time to get up in the morning. So, I mean, trivial rights like that. And of course, we didn't intend to give up all of our other rights just because we were giving special constitutional protection to some of them. And the same argument can be made about powers. But here's the key thing. The framers intended to have opposite results from the silences of the list. They intended that the list of powers be exclusive, so that if a power isn't herein granted, it was left to the states. So the list of powers is not just illustrative. It's intended to be compendious. It's intended to be exclusive. But the opposite rule of construction was what they wanted for rights, that just because we're listing, speech and religion and criminal procedure rights and property rights and so forth, just because we're listing some of these things doesn't mean that we're giving up the others. We may not be making the others constitutional rights, but we're leaving them. We're not taking them away. We're not affecting the others. And this might have been clear just because that's what people intended and probably what most people would have understood. But the framers were not content, and especially the anti-federalists, who were really sticklers for reading the language very carefully. They weren't content with that. They wanted it to be spelled out. And so they adopted these two amendments. I'm gonna share a screen here with you so that I can show you the actual language of these amendments. I'm not Mr. Technology here, so I was a little slow on doing it. Let's begin with the 9th Amendment, since 9 comes before 10. So the 9th Amendment provides the enumeration in the Constitution, in other words, the listing in the Constitution of certain rights shall not be construed to deny or disparage others that are retained by the people. In other words, we have lots of rights: the right to wear a hat, the right to decide what time we're going to get up in the morning, some very important rights: the right of self-defense, the right of parents to control the content of the education of their children. There are lots of very. I don't mean to make fun of this, using the First Congress's examples of hats and getting up times, because some of these are really important, but they're not all listed. And so the 9th Amendment makes clear that those were not taken away. The remuneration shall not be construed to deny or disparage others that are retained by the people. We still have them. Now, what are they? There's a lot of modern scholarly dispute about what is the status of these other rights. Some people take the position that the real meaning of the 9th Amendment is that the courts have authority to, look at the list of Bill of Rights and then find rights of similar importance and treat them the same way. That is, to elevate some of these rights that are not enumerated and make them into constitutional rights. In a way, this is what the abortion debate is all about, but it goes way beyond any one issue. At least for purposes of the 9th Amendment, I take a different view than this. I think that when it says that the other rights retained by the people are not denied or disparaged, but instead are retained, I think what that means is that they have exactly the same legal status that they had prior to the adoption of the Bill of Rights. That is, maybe they were common law rights. They remained, in which case they are still common law rights. Maybe they are rights under state constitutions. Well, in which case they are still rights under state constitutions. I do not agree with the scholars who say that the Ninth Amendment means that these other rights retained by the people are of equal status with those that are enumerated in the Bill of Rights. I think instead they have whatever status they had before the Ninth Amendment was adopted. So it's a kind of hold harmless clause for liberties. And you can see how, if that is what it means, it's not something you're going to take to court. It's just a principle of construction to prevent the government from reasoning that because something isn't mentioned in the Bill of Rights, that it necessarily is not a right of any sort. Remember that the idea of rights is much broader than just constitutional rights. We have rights that arise from all kinds of different sources of law. So the 10th Amendment here takes exactly the opposite view of the significance of enumeration. It says the powers not delegated to the United States by the Constitution. So in other words, if the power is not on that list of powers in Article 1, Section 8 or delegated elsewhere, if it's not delegated to the United States, and it's not prohibited to the states, and that's a reference to Article 1, Section 9, which lists certain powers that are specifically denied to the states. So if the power is not delegated, and there's certain other powers that are implicitly taken away from the states elsewhere in the Constitution, the power is not delegated to the United States by the Constitution, right? So it has to be the document itself, where this is a evidence that the framers were really textualists, nor prohibited to it by this, are reserved to the states respectively, or to the people. So comment on several of the words here. Reserved to the states, that suggests that these were all powers that the states had before. So the 10th Amendment is not the source of any additional powers, but rather ensures that the powers that were in the states prior to the adoption of the Constitution remain in the states unless those powers were given to the national government or denied by the Constitution to the states. And it says, or to the people. And this is an acknowledgement that there are some matters over which the government itself, whether federal or state, the government itself has no authority. That there, a good example of this would be the power to regulate religion or to determine an established church. We have an amendment about that, to be sure, but even without that amendment, the Constitution does not give to the national government the authority to regulate religion, to establish a religion. It leaves, and the 10th Amendment says that's left to the states or to the people. Well, how do you know which that's going to be? At the time of the founding, roughly half of the states had some form of legally established church, some form of legal establishment of religion. And so in those states, this power over religion is reserved to the states. And in the states that don't have that, about half of the states at the time of the Constitution had no established religion. In those states, the power over religion is left to the people. It's reserved to the people. But the important point about the 10th Amendment is that these things are left to they're not delegated to the United States. They will not be exercised by the United States. The courts are not empowered to reason along the following lines. Well, this is an important power. This is something the national government really ought to have, and therefore we are going to imply it or assume it to be a national power. Now, there's another important provision of the Constitution, the last clause of Article 1, Section 8, which says that Congress does have the power to make all laws that are necessary and proper for carrying into effect the preceding powers. So that's an acknowledgement of the fact that powers, in order to do certain things, they're incidental. Their power is going to be incidental to carrying those out. A simple example might be that if the Congress has the power, as it does, to create a post office, that it also has the power to pass a law prohibiting theft from the mails. So that would be incidental to establishing a post office. An incidental power is a lesser power which is in service of one of the enumerated powers. And Congress does have incidental powers necessary and proper to carrying out its express powers. What it doesn't have, although the Supreme Court has sometimes said otherwise, I think wrongly, what it doesn't have is implied powers, which is to say, the United States must have this power because we think it's really important. Well, that's not an appropriate way to reason under the 10th Amendment. The last thing I want to say about the 10th Amendment is that it was actually a disappointment to the anti-federalists who proposed it. 3 times in the first Congress, they made a motion to change the wording of the 10th Amendment. But the anti-federalists, who are, I mean, this is a sort of a crude generalization, but you might understand them to be advocates of greater states' rights. They wanted to have this amendment read, the powers not expressly delegated to the United States by the Constitution, and so forth, not expressly delegated, because they were worried about the possibility that there could be incidental or implied powers. That was rejected. Madison, among others, said that that would make government unworkable. If you can't do anything except what is expressly delegated, well, government would not be able to operate. The word expressly is in a similar provision within the Articles of Confederation. So the absence of the word expressly is very significant here. And so the courts from McCulloch against Maryland on have basically reasoned that the 10th Amendment is, it's really, 10th Amendment turns out to be a double-edged sword. Yes, it reserves to the states all the powers not delegated to Congress, but it does recognize that they don't have to be expressed, so there can be incidental powers. So it's not as clear and straightforward a states' rights provision as its advocates sometimes suggest or wish that it were. Now, I've now talked my allocated 30 minutes. Let me just say quickly, the 11th Amendment, which is litigated quite frequently, was added after a Supreme Court decision called Chisholm against Georgia, in which a citizen of another state sued the state of Georgia for damages, and this offended widespread understandings of what states' sovereign immunity would amount to, and so the 11th Amendment was added to provide that the Constitution should not be construed to allow. Here, let me read you the exact language. of the 11th Amendment. It's the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States, that is, by citizens of another state, or by citizens or subjects of any foreign state. And in a case called Hans versus Louisiana, the Supreme Court extended that to being suits by a citizen against their own state, which is Hans is a highly dubious and much criticized decision, but has been left in place because it's been around so long under the doctrine of stare decisis. But the effect of this, of the 11th Amendment, is that in many areas of law, it is not possible to sue states as such for damages, even if you would otherwise be entitled to them. By damages, that means, for a money remedy. You can sue them for getting, for invalidating laws, for injunctions and so forth. You can sue officers of a state under certain circumstances, and you can also sue states pursuant to to legislation passed under the 14th Amendment. So there are a number of complicated exceptions to this idea that you cannot sue states, which is why federal jurisdiction courses in law schools are some of the most complicated and difficult and intellectually challenging of all the subject matters. I can't begin to summarize the jurisprudence that has come about as a result of that, and therefore I will subside, and I look forward to addressing your comments and questions.
Professor McConnell, what a fascinating lecture. I really, really appreciate your time, your talent, and your clarity in being able to explain complicated situations. So here's my query. Remember we warned you about our audience, and they're relatively sophisticated. So here we have one of our members indicates that he understands that in some interpretations of the constitutions, it has been said that the founding fathers meant to create something close to the perfected system of government pitched by St. Thomas Aquinas, who said it was to be a combination of a monarchy, an aristocracy, and a democracy all at once. Now, has the 17th Amendment, which changed the Senate from the aristocracy of appointed senators to elected senators, changed that? Do you have thoughts on that particular comment from our audience?
That's an interesting question. There was a lot of interest in this theory. It doesn't just come from Aquinas. It actually goes all the way back to Aristotle, and it's often called mixed regime theory or balanced government. Blackstone talks about this, and Montesquieu talks about this. And the idea was that the few, aristocracy, and the many would all be part of the government, be able to check each other, so that if one of those got to be overly powerful and oppressive, the other two would sort of gang up on it and bring it back to size. The problem for the United States is that we didn't have a monarch, and we didn't want one. And we didn't have an aristocracy, and we didn't want one. So there's very interesting discussion at the Constitutional Convention about how we might achieve some of the practical advantages of a mixed constitution when we don't have the social wherewithal, the social classes needed to do that. And one of the ideas, and this is primarily associated with John Dickinson of Delaware, one of the ideas was to use the states as a kind of substitute for an aristocracy. And so our three branches of government are actually elected not all by the people directly at the beginning. The House of Representatives would be the popular branch, elected directly by the people. The Senate, up until the 17th Amendment, the Senate was elected by state legislatures, right? And then the president is elected by electors who are chosen by the people, but the people don't directly vote for president, they vote for the electors. That's the way it was understood. And the hope was that you would get a different kind of perspective, that the House of Representatives would be immediately responsible to the wishes of the people, but that the Senate would have a somewhat more detached perspective, maybe a longer view. They're elected for 6 years, a very long term, instead of the 2 years. And the hope was that maybe they wouldn't be worried about the next election cycle. Instead, they could think about the longer term consequences of policy. By the time of the 17th Amendment, the United States, with the people of the United States, have really become more democratic. Mixed regime theory is not pure democracy. It's has a democratic side, but it also has an intention to check democracy. And by the time of the 17th Amendment, that wasn't in vogue anymore. And instead of having state legislatures choose senators, the people of the United States voted through the 17th Amendment to elect them themselves. Now, to be fair to the 17th Amendment, part of this is that Senate didn't turn out to be much of an aristocracy anyway, not an aristocracy of talent and the state legislatures were in somewhat ill repute. They were often corrupt, often dominated by special interests or by one party. And so the hopes that the Senate would have this sort of more lofty character to it were not entirely borne out. Although I want to say there's a historical debate about that. The Senate did produce a lot of giants in the 19th century, but anyway, that we got away from that. I think the biggest difference from the 17th Amendment is not really the aristocratic side, which was never very aristocratic. That really never panned out. What it really did is it eliminated the state, the voice of the states as states in the passage of legislation. So under the original scheme, every law passed by Congress had to be approved by representatives of the majority of the people and also representatives of a majority of the state governments. And so that may be one of the reasons why in the years since the 17th Amendment, the national government has grown so much more powerful at the expense of the powers of the states, as the states no longer have a direct say in the passage of legislation.
Fascinating. Now, there's a growing movement that sort of comes and goes of states calling for a new constitutional convention. Can you give us your perspective on that movement and what are the risks and benefits of such a thing?
Yes, I forget the current count, but we're 1 or 2 states away from this, depending on how it works. The Sixth Amendment provides for a constitutional convention when called for by 2/3 of the states, but it's a little unclear what that means. Does that mean that the states have to have made the same call? What if some of the states are pushing for a balanced budget amendment and other states are pushing for an equal rights amendment and other states are pushing for something else? Does that add up Do a bunch of states that want different sorts of things add up to a convention? We don't really know. We don't even really know who will decide, although my guess is the Supreme Court will probably decide, but we really don't know. And is it a good idea or not? As the director of the Constitutional Law Center at Stanford, I held a conference, I don't know, 4 or 5 years ago on, I called it The Big Fix, in which I invited leading scholars from all over the country and asked them, how should we amend the Constitution? And I was actually surprised, genuinely surprised, at how minor the amendments were. People had very, certain fixes, some particular things they had on their minds, but big fixes, not so much. I'm going to shut up about this, but if you're interested in what new constitutions might look like, the National Constitution Center has on its website, what they did is they commissioned 3 teams of scholars, a conservative team, a progressive team, and a libertarian team, and asked them to propose new constitutions and then explain why. And if you're interested in what might come of a convention, maybe that's as good a place to look as any, and just look on their website for the Constitution drafting project.
So from your knowledge of having studied this, having convened, the conference a few years back, what are your predictions? Will we have a new constitutional convention, or will we just continue to talk about it as a concept and decide we can't really risk it?
I don't know. I would guess not. I mean, some people want one, but I think most people are scared. That is, most people would, I think there's widespread view that our Constitution is outdated in various ways and should be improved. But I would guess that most people are more frightened of what other people would want to replace it than they are hopeful for getting their own views. I mean, our country, one of the great problems in the country right now is a lack of trust among not just of institutions, but of each other, right? That increasingly we see people of the opposite political persuasion not as fellow citizens who all have good faith efforts in different ways to think of how to improve our lives together, but rather as enemies and threats to liberty. And I mean, we lots of people say, one political party is a danger to democracy, and another says that the other political party is going to bring about socialism. And it's like when you treat the other side as being a suspect, not as somebody to really talk to and engage with and possibly learn from, it's very hard to have a useful political conversation. And I think many of us believe that a constitutional convention would just break down in this kind of divisive, contentious way and not produce anything constructive.
And how about this question? The 14th Amendment was passed after the 9th and 10th were already part of the Constitution. Did the 14th Amendment change the dynamics because it expressly gave Congress the power over state governments on certain areas?
I think the answer to that is unequivocally yes. The question makes me wish I should have made some comment about the 14th Amendment in my introductory remarks. This is true both as to rights and as to powers. Just very briefly, as to rights, The original Bill of Rights applied to the national government. It says, the First Amendment begins, Congress shall make no law respecting establishment of religion or abridging the freedom of speech, etc. It applied to Congress, not to the states. And we learned through the experience of slavery that the states were actually a great danger to individual liberties. They were locking up abolitionists and shutting down abolitionist preachers, and I won't go into all the details, but not just, it isn't just that slavery itself was a violation of individual rights, but the slave system restricted individual rights in countless different ways. And so the 14th Amendment provides that the privileges and immunities of citizens of the United States, which is the constitutional terminology for freedoms, privileges and immunities are basically means rights and freedoms, privileges and immunities of citizens of the United States may not be abridged by state governments. So that applies fundamental liberties to the states. And then in Section 5 of the 14th Amendment, Congress is given the power to enforce that. So the whole system of rights protection was altered by the 14th Amendment, and with rights now protected against states, but with the national government and specifically Congress as the enforcement agent. That's a huge change. So many of our modern important statutes, think of the Voting Rights Act, for example, or federal statutes designed to protect individual liberties of one sort or another. That is important for our liberties, but it's also significant for the federal state balance, because this is just an enormously important source of power now vested in Congress that wasn't there before. And as to the powers, I've already commented in a way about the balance of power, but very specifically, the 14th Amendment was understood to give, because it's prohibitions on the states and a power granted to Congress to enforce it, this enables Congress to pass legislation which provides for suits against states and thus to override the 11th Amendment under certain circumstances. So yes, the 14th Amendment made a very big difference.
And do you see, from where you sit and all the folks who talk to you, are there current challenges that cite the 10th Amendment that the Supreme Court could potentially hear in the future? Will we see the 10th Amendment being looked to?
Probably so, but I can't name chapter and verse here. The 10th Amendment is invoked from time to time. The Supreme Court has said, although not all the justices would subscribe to this, but they have called it a truism, in the sense that what the 10th Amendment says is if the power hasn't been granted to Congress, it hasn't been granted to Congress. That does sound a bit like a truism. So the guts of 10th Amendment litigation is really not about the 10th Amendment. It's really about whether the power has been vested in Congress or not. So that forces us to debate the content of the various power granting provisions, most of them in Article 1, Section 8. And of course, we see that the Obamacare case was the most recent big example of litigation having to do with does Congress really have this power? In that case, being the power to compel individuals to purchase private health insurance. Does the federal government really have that power? And those cases, come up regularly. I'm not necessarily every year, but certainly with some frequency.
And now let's talk, you mentioned briefly the 9th Amendment with regard to the Roe versus Wade decision, the Dobbs decision. would you like to give us your perspective on how the Ninth Amendment might or might not have influenced the right to privacy, the right to abortion?
I really brought that up by means of analogy, not because the Ninth Amendment directly applies. The Supreme Court has never held that the Ninth Amendment is an independent source of constitutional rights. The debate over whether there is a right to abortion in the Constitution really rests in the 14th Amendment, not in the Ninth Amendment. And there, the question is either what's called substantive due process, the idea that no one can be deprived of life, liberty, or property without due process of law. Does that actually provide a substantive limitation on what kinds of laws can be passed, or possibly the Privileges and Immunities Clause are the privileges, no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. Does that include non-enumerated rights? And so the debate over abortion is really located elsewhere in the Constitution.
And tell us this. This is sort of one of our favorite questions. We ask this about everybody when we talk to them about the amendments. In 1789, which was the year the Constitution was ratified, Thomas Jefferson wrote to James Madison, "Every constitution and every law naturally expires at the end of 19 years. If it be enforced longer, it is an act of force and not of right." So to what extent should the framers' original intentions matter to us today?
So 19 years was at that time the best calculation of a generation. And so what he meant was that, well, one generation can't legislate for another. And he thought essentially we should have a new constitutional convention at each moment. James Madison, by the way, Jefferson had no direct connection with the Constitution. He was off in Paris as the ambassador during the entire Constitutional Convention, and who knows what he would have said. He didn't particularly like the Constitution when he first read it. Madison took the opposite view and believed that constitutions provide long-term stability, and that it's a kind of it's like a legacy to the from one generation to the next. And of course, constitutions should be changeable, but that you don't rip it up and create and sort of try to start afresh at every moment, at every generation. So, I think it's pretty clear from the text of the preamble to the Constitution that the framers and the people in adopting the Constitution took Madison's side of that rather than Jefferson, because the Constitution says, we the people of the United States do ordain and establish this Constitution for ourselves and our posterity. Now, maybe they didn't have a right to do that, but that's what they thought they were doing.
Turns out they did. We're about coming to 250 years, so they were right. We'll do one last question, and then we need to wrap, and we are so grateful for your time. So let me ask you this question. One of the things that someone raised is, do you think if the federal government were to pass a national law with regard to abortion, would that potentially initiate a 9th and 10th Amendment challenge? That Congress had gone out over their skis?
Well, the argument for a national law is that however you look at abortion, from one side or the other, it involves individual rights, and and Congress has the authority through Section 5 of the 14th Amendment to pass appropriate legislation. So that's why both a national a law protecting abortion rights nationwide might be constitutional, and that's why something like Lindsey Graham's proposal for a nationwide cutoff at 15 weeks might be constitutional. I think that is probably right. It's hard for me to see what the flaw is in that argument, but I would say this, that the genius of the federal system is that it allows people in different parts of the country to be different. The people care very intensely about the abortion question, but they feel in different ways. So people in Texas don't have the same view as people in California or New York. And the virtue of federalism is that the laws can be tailored to the wishes of the people of a particular state. Now, that's overcome when there are powerful effects of conduct elsewhere, like pollution, for example. But it could be that we might very well have had a more peaceful approach to this issue if Roe versus Wade had left the abortion question to individual states from the beginning.
Well, this, as always, this leaves us with more questions than answers, but with a lot to think about. We really appreciate, Professor, your time. And we are so grateful that you have joined us. As we move forward, we want to encourage our members to think about joining us for the next in this series, where Joanne Freeman will be joining us to talk on December the 1st about the 12th Amendment in the context of the party wars, Jefferson versus Adams, Hamilton versus Burr, and the need for the 12th Amendment. And this screen that is before you shares with you other programs, because we don't just do the Constitutional Amendment series. We have our Capital Kids program, which is authors who have written about books that are particularly geared to children, about Congress, about Washington, D.C., and about our rights and responsibilities as citizens. And then we also get opportunities for authors to come and talk to us about topical items that have come into focus that we weren't expecting. So we have The Bridge of Spies, which is about the capture of Francis Gary Powers and the current state of U.S.-Russia relations. It's sort of hankers, but you hear that and you think about Brittany Griner and what is going on with the holding of prisoners between American prisoners in Russia. And we all know that Thanksgiving is our national holiday. Controversial, yes, it is. Last year we had a fascinating scholar talk about the Wampano Indians and the Thanksgiving from their perspective, which was not a matter of celebration. So this year, we're going to talk about how did Thanksgiving become a holiday in this country, from the Pilgrims, the Wampano, to Washington and Lincoln. So on the Tuesday of Thanksgiving week, we invite you to join us. And our magical tech guy, Sam Holliday, has created this QR code so you can take your smartphone and you can scan it, and that'll take you right to our website in coming events. If you are a little less techie than that, you can just go to the website for the United States Capitol Historical Society and find all this information. Thank you, Professor. Thank you. And we appreciate everyone who has joined us. We remind you, as always, that these programs come to you only because of the support and generosity of our donors and our members. We thank you for your contributions, and we hope you'll continue to inspire informed patriotism by investing in the Capitol Historical Society. Have a great day.